Anant Deshpande sir. Dr. Deshpande sir is from Chhatrapati Sambhajinagar. He is past president of Maharashtra Ophthalm Society and is also on the Medical Legal Committee of All India Ophthalmic Society. So, welcome sir. I will be speaking on dealing with legal notices. Be practical and prepared.
Yes, myself, Dr. Deshpande. Uh, what patient has sent a legal notice? Generally, whatever happens, whether it is happened with the patient doctor, whether it has happened with the staff doctor and patient, or somewhere, whenever their patient comes in the premises of the hospital, and if he is not satisfied, he can send a notice. But what is the importance of that notice to the doctor and hospital is also a very important thing. And what should be your next step when the notice is there? But generally, as we are little bit ignorant of the law, we immediately get disturbed because of that notice. And we start writing something, some answers, this answer, that, and you try to defend yourself. Whenever you are defending yourself, you are making so many mistakes because you are not a lawyer, not a law person, not know what that should be answered that way. But that the answer which is given in the legal notice can be used in the court against you if it is something written wrong. So what one should do? So as I am a legal committee, All India Ophthalmic Association, at this place I will like to say that we are shortly forming SOPs for everything which is going from patient coming in the OPD section to discharge and follow-up for everything, which many consultants are being involved in that for doing the SOPs of specialty. And why the case is lodged, that is the main thing. Previously, it was only the clinical results that patient did not got and patient used to go in the court or give out the notice. But now, it is not that. Previously, behavior and other problems were not of importance. But nowadays, behavior of the doctor, behavior of the staff, ambience is also a matter now. If you are not clean, hospital is not clean, your bed sheets are not changed, your latrine and bathrooms are not clean, they feel and they can send the notice. And instigation is the most common thing. Very, very small thing that I will like to say to all the practitioners, that we allow the patient and we say that one or two people with them. That is very bad method of saying that only one or two patient relations should attend with the patient in the cabin. So other get feel that are we not important? Are we not really important for this patient? And they get disturbed and they instigate the patient. So better to allow them. It is nothing wrong for getting 3, 4, 5, 6. The 2 chairs are there, 2 will sit and the remaining will stand, definitely. But everybody will be satisfied, and that satisfaction is very important in the medical field. So never say that only allow 2 accompanying people or 1 accompanying people. So the instigation is not by only the relations, but there are so-called leaders in the town, particularly in villages. They say that they are not given the importance or they instigate, and for so many reasons, for this and that and frivolous complaints for earn the money is also a very common thing nowadays because of the Consumer Protection Act 19 has a provision for that, I will say. Patient himself or through a advocate, how the notice is sent. Patient can send himself a notice or he can send through the advocate. Should be cognizance taken of that notice? No. If you are going to answer that notice, better to have a medico-legal consultant or at least an advocate and then answer, otherwise don't answer. It is not mandatory to answer that notice. But when the notice is sent by the civil court, consumer court, or the national NMC, that is National Medical Council, or state medical council, or police station, or criminal court called as warrant, or other agencies such as health services, corporations and all that. That notices one has to answer. And answering that notice, don't say that I know everything. I am the master of everything and I will write the notice answer very nicely. You are nowhere because you are only master in your clinical field. I agree. You are master, super master. But in other fields you are not master. You take the help now, and helps are available at every step. And that is very important. Unless you take the help, you make the mistakes, and that mistakes causes the punishment in the courts. So he will not refuse the notice, as even if you refuse, it will be taken. Many times the people think that I don't take the notice, so what will happen to me? Nothing will happen. I was not communicated. It is not true. If the notice is served, he will write it was served, but he refused. And the intention of the giving the notice is to only inform, not to let them know what the things are there in the notice. So never refuse a notice. It is not mandatory to answer the notice of the patient or the advocate that I just now said. Other notices answer with help of the advocate or medical legal consultant. Have indemnity insurance, as doctor said just now. Then don't become panic even if you have received a net notice, because you are having nowadays many people around you, medical legal advocates and all that. So medical legal cases charged may be a case under the Consumer Protection Act 19. So there is a difference in between. I will categorize the notices in three. That is, one is Consumer Protection Act, that is a civil charge. Another is a criminal notice in the criminal court, that criminal offense has been done. And third is administrative, that your latrines are not clean, this is not clean, you are not registered, your hospital, you are not registered for disposal of the cases, and all these are administrative. But notices can come from the health departments and the ministers and MPs and that also you have to take the cognizance, because they are from the part of the public. Maybe a part patient, maybe a part of the public. So all these types of the notices are there, but the clinical notices are only, many legal notices are only criminal or the civil. The mode of action differs according to whether the case is lodged. So when you are answering a notice, that mode of action changes if it is lodged in the consumer court, whether it is lodged in the criminal court. Apart from that, FIR or private medical legal case, the FIR is lodged for private criminal case is lodged, then take the help of the medical legal consultant. He will ask you the court to opinion of the medical board, and then only negligent is not gross, case will not be dismissed. So whenever the criminal case is lodged, FIR is there, or the criminal case is lodged in the criminal court, there will be a notice from that. And if they, even the FIR is lodged, they have to take the opinion of the experts, whether it is a true or not, and then the case will proceed. Otherwise, it will be dismissed there only, or the court will dismiss, because before dismissing, he will have the opinion. But there is a mandatory for criminal cases only to the court. In civil cases, there is no mandate. If the court desires to take the opinion, will take the opinion, otherwise not. So police statement, police can come to you and ask for the giving the statement. You can give the statement, cooperate with the police, but need not to sign the statement. It is statements are never signed. Police can ask the that is a record. You should show the record. But when they are seizing the record, they are taking it, have a copy of the record and ask them to do the panchanama. that is called as Panchanama, which is to be done, and the copy of the Panchanama should be preserved with you, and that should be shown in the court that the originals are being taken by the police. Otherwise, the court will blame that you are not having the originals. So now, whenever a complaint is received against a doctor or a hospital by the criminal court, then before, as I said, when the court receives the complaint in the complaint, they will send all the documents to the experts or a government of civil surgeon or medical board, and will take their opinion, and then will decide. And when you are for a few minutes, Dr. Shah, you will have your written statement in the consumer court. The consumer court is totally different, and in that case, you have to give the written statement, and that written statement is the important thing, which decides the case totally. And so you should take the help of the medical legal consultant. And nowadays, Consumer Protection Act 19 has changed a lot, and the negligence is not the only cause of your case. And if whether you are where you are working, whether you are a solo worker, that is solo practitioner, you will be case will be on the you. But when you are working in an organization, trust hospital, corporate hospital, or somebody else's hospital, the whole blame or whole goes to them, because in consumer it is said whosoever pays is consumer, and whosoever gives the services is the service provider. And in that hospital is service provider and doctor is not the service provider, because doctor gives his services to the hospital and not to the patient. Though indirectly they goes to the patient. Role of the medical legal consultant, and that was decided by the Supreme Court, and they said that whenever a patient comes to such hospital, it comes with the name of the hospital and not on the name of the doctor, though he may be coming on the name. But bill is taken by the hospital, bill is not taken by the doctor, bill is not maybe shared, but not totally going to the pocket of the doctor. So he is not a service provider, and patient is not consumer of that doctor. So he is away from that case totally. So this Supreme Court decision is in favor of that, and so doctor did not to worry. And indemnity insurance has said, and how to avoid a case is speak less, hear more. Thank you very much.
Thank you, sir. That was the right way to tackle legal notice that you receive whenever there is some mishap or a patient feels that there was some negligence. You should not panic, but be prepared and go about it step by step. So if there are any questions from the audience, you can take it now.
If there are no questions, I just want to ask Deshpande sir, if suppose a government doctor gets notice, then how to proceed further?
First thing, that government doctor cannot get a notice of a consumer court. If he gets a notice of the consumer court, that is the responsibility of the government. Even the government hospitals, like medical colleges or the government hospitals, where the charges are charged to the patient according to their income, may be minimal. They are consumers, and so they have to do all that, and doctor is the service provider. He is on the contract of the service, and he is not the culprit. Secondly, whenever a government doctor hospital, when working in the hospital, he gets the notice from the upper higher authorities, that is the DHO director or somebody else, or the political leaders, he has to inform to the hospital superintendent or hospital head, and they will answer, and he will be answerable to the hospital, not directly to them, because he is an employee under the contract of employment, and he is not the whole soul who has to answer everything.
Sir, how much insurance you suggest? You mentioned about
nowadays you cannot say how much is sufficient, but at least I will say minimum 1 crore should be there. And for that, Maharashtra State Ophthalmic Association and All India Ophthalmic Associations are brought the premium from 30,000 for 1 crore to merely 6,000 by AIOS. and 8,000 by Maharashtra Ophthalmic Association. So one should have at least 2-3 crores, because 5,000-6,000 per crore is nothing. Once we go in the canteen or hotel, we spend more than that. So why should not be peace of mind? You should not have that.
Yeah, thank you, sir. One more question. While taking this insurance, there are many companies which are providing this insurance, and there are many rules which we usually don't read. What you should really see in the condition part of this insurance while taking this insurance?
Yeah, there are two things very important you have to see, and that is when you are taking a 1 crore limit. Suppose I am saying 1 crore. What is the ratio that 1:1, 1:2, 1:4, 1:4? That ratio matters a lot, because that ratio says that in 1 year how many cases you are going to deal. So if the ratio is 1:1, the whole 1 crores is compensation is available at your hand if the court orders. And if it orders less, suppose 60,000, 60 lakhs, then remaining 40 lakhs remains for next case. But when you put it 1:4, only 25 crores remains with lakhs remains with you for paying by the insurance company. Remaining you have to put from the pocket. So that is a very, very important thing. Never see that what is the ratio, and never accept any 1:2, 1:3, and 1:1 is the best. Secondly, your part of payment, there is a clause. From your pocket you have to pay something, 10%, 5% or something, and that should not be very high. So see that it is a minimum when you are taking. And best way is for ophthalmologist, at least though both the things, AIOS is there and MOS is there, and group insurance has brought a lot of things, but it is not the group, but the member insurance in group. So everybody is having their own individual insurance through AIOS agency. So that is a secured one.
Yes, sir. That was a very well taken point. 1:1 or 1:3.
No,
1:1 you have to
Yeah,
always
1
go
is
for
to
1.
1.
It means that if you are insured for your professional indemnity insurance is for 1 crore, if there occurs more than 1 cases, for each cases 1 crore will be allotted.
Yeah.
Whichever case gets decided first,
Yeah.
some payment will
Yeah,
be done
yeah.
in the next year.
But generally, any
But
doctor
if there is
or
a cluster,
hospital-
some 5-6 cases occur, and they all go simultaneously, so 5 cases, for each case 20 lakhs will be maximum applicable limit for that year.
Generally, a individual doctor generally happens more than 1 case in a year. Next year again the same is there. So better to have 1:1.
Yes, please, sir.
Please.
I'm seeing an example where due to false case, the complainant has been taken charge of by the court. The doctor has been compensated for defamation.
If the false case is there, you have to prove that it is a false case. And if the false case, you cannot prove that it is a false case, you have to pay the compensation. It
Ne-
becomes true case then.
What was the case? What was the case?
My question is, they have complained, and during the proceedings, they are somebody has instigated it as a
Settled. They have settled the case.
in the court only that these people have trying to frame the hospital or a doctor. Does it go naturally to the point that the complainant has to give compensation to the institution?
Now,
Or
in
you have to take it for actively take it up later?
No, you have to actively take it up for perjury and against false under section 206 of Bharatiya Nyaya Sanhita, registration of false complaint against a doctor. You have to prove that there was such a complaint. You have to go to the police station and say such false complaint was there, and again that will be a separate case. This will be a separate case. Right, sir?
Yeah, I will add to this. False complaint, whether it is a civil or a criminal. If it is a criminal, even if you register another criminal case on him, it doesn't matter, it will separately go on. In civil case, that it goes to the media. Now, mediator. Every case goes to the mediator, and mediator you
consumer-
have to say
in consumer
something
court.
and then settle if you want to, or you contest again. Yes, please.
Like you have told in your talk that if police comes to the hospital,
Better have mic, madam.
You can come here. You can come
Or
here.
come here and speak with the mic.
morning, sir.
Yeah.
Like in your talk, you have told that if police comes to the hospital and asks for statement from the doctor, and the doctor is giving the statement, but he's not signing it. What is the idea behind not signing the statement for the police?
Yeah, that signing is never given to the any statement to the police, any whatever. It is not for the doctors only. For others also, when the police is doing the enquiry, that is their enquiry statement, and that is not your commitment or declaration. When you sign it, it becomes your declaration.
And it stands in the court then?
Yeah, it stands court,
okay.
but courts refuses to make it stand. They say that why you have taken the signature, this fire the police only.
Okay.
Because so moto we don't do. So they forced to sign.
Yes.
So courts say why you have made it to sign. But generally they don't force you or say that sign it. That is their rule.
So if you
Because-
don't sign, then it is not a declaration, it is
Yeah,
just a
yeah.
statement which can be changed afterwards.
It
maybe.
is your legal right if you
Yeah.
don't want to sign.
Yeah.
You
Okay,
can
it
give
is
any
our legal
statement.
right.
becomes-
that
whenever
we
you
should
sign,
know.
it becomes
They can
actually.
note down anything
Because
on the
the
statement.
policemen,
already,
they might force the doctor, and we are not aware many times.
Even if you
most of the
sign,
times.
it doesn't stand in court.
Okay.
Yeah.
One
But,
point. Second point, it is a tactics by the police department
yes.
that once you sign, you will not waver from your whatever you say.
yes.
You say something now, and they go through that investigation line, and then you completely do a somersault and say something else. So their whole time is get wasted.
that is-
so that
but
is
that
their
is
police
false.
tactics.
That-
No, secondly, patients are very clever. They put the cases both place, at criminal and civilian consumer.
Okay.
And whenever you sign the statement, that
stand in
there,
consumer
they
court it is stand.
produce it in the consumer
Okay.
that he has agreed this. So agreed this means that
So
is
in
sufficient.
consumer court, it stands if we
It
have
stands,
signed
it
before.
It has
stands
some
because that
weightage.
is a
It has
document.
some weightage.
Okay.
Yeah.
So
it
we should
has-
not better it
yeah,
is
it
not
has
to
weightage,
sign.
Yeah.
Okay.
It
Thank you so
stands.
much, sir. Thank you.
One last thing.
Yeah, please.
The importance of video recording of consent. How important is that nowadays?
Yes, video consulting.
Also, or only in high risk?
Yeah, now the NMC has made compulsory the writing or everything should be a computerized one. Within after the 3 years, that should be 1 year is passed. The NMC has directed everything to be converted in computerized
Electronic medical
matter
records.
in 2 years again. So whenever you are taking a video consent, it is not the video consent of saying. The hard document should be there, should be signed, and that signing and everything, and when you are explaining everything, the complications and all that, that should be in the video.
3 years.
Yeah. But whole the thing, you just said that video and he said, okay, I agree. That is not sufficient.
What sir is saying is after 3 years it is going to become compulsory
Yeah,
for
compulsory.
everyone. That is what NMC has recommended.
Yeah, recommended.
And for what period of time you have to keep that video, that is a separate question. And one, it is not mandatory right now, but it is desirable if you can take video consents.
And
But
in-
written consent is a must.
And in future, it will be compulsory to capture his thumb and his face also, because that is the
Biometric,
identification
yeah.
of the. Many times they sign it and they say in the
This is
court that
not
this
my-
is not my sign. So better for our safety at present, you should have a thumb impression attached to your computer and a camera which captures his image and put it on his case paper, both the things. So it becomes revealed to everybody that you have not done anything wrong.